Good morning, everyone. Greetings from TeamLease. Welcome to the webinar series on labor law reforms and the impact on the employers. Today, we have the first of the four webinar series, which is on the Code on Wages Bill 2019. The speaker of the webinar is Ms. Rituparna Chakraborty, co-founder and EVP of TeamLease Services. She is also the president of Indian Staffing Federation. We have few guidelines for the webinar. Attendees are requested to make use of the chat box that appears on the right hand side of the screen to raise your queries. Please note this session is on the Code on Wages Bill 2019. In interest of time, we might not be able to answer the questions on other laws and codes, but please write back to us and we'll be happy to answer them. Now I request Ms. Rituparna Chakraborty to commence the session.
Good morning, everyone. I think I'm really humbled to see the number of registrations that have happened for the Labor Code series and the kind of interest that is generated. Actually, we've received a lot of questions even before the session commenced, and that's extremely encouraging. Like Abhishek just now shared with you, I don't think we would be able to probably on account of paucity of time respond to all of you, especially the ones which are pertaining to stuff which is outside the scope of today's discussion. However, let me assure you, we will write into each one of you or respond to each one of your questions. I guess, and most importantly, I should start today's conversation with a disclaimer that I am not an expert of Indian labor laws. I'm not a lawyer myself. However, I think I'll try and bring in a practitioner's perspective. And our approach to today's labor code discussion would be to kind of explain some of the nuances which you should be aware of from a layman's perspective. A simplified version of the otherwise extremely detailed Gazette notification that has come out. So I guess all of you must be aware about the complexity of India's labor ecosystem. And I think there are many consequences of these complexities. I think that the consequences on jobs, consequences on formalization of jobs, and I guess the list is quite long. I think at some level it does impact ease of doing business, and everything else downstream is a trickle-down impact. So I guess there has been a lot of dialogue and there has been a lot of voices which have been actively requesting or actively propagating the need for a relook at the way labor laws are being structured in this country. And from that perspective, I think the four labor codes are a welcome break. Now, just to get an understanding, I mean, do you have any idea how many labor laws are there in this country? Anybody has any idea how many labor laws are we talking about? Okay. Yeah, there are about 44 central labor laws, and the state-specific labor laws actually are in excess of hundreds and hundreds of them. In today's scenario, any organization in this country or an average size organizations in this country, we are looking at almost 58,000 compliances to be done every year. And out of those 58,000 compliances, in excess of 26,000 compliances get done in the area of labor. And that is a scary number. And I guess a lot of non-compliance in this country, of course, happens on account of lack of awareness around these compliances. So while there is a certain population which is doing it by intent, but there is a large population out there which is not able, for them, intent is not a challenge, awareness, information is a challenge. So I guess in keeping in mind this context, I think the four labor codes emerge as, if not a perfect solution, but a solution in the right direction to kind of simplify the labor ecosystem. I think what the labor codes have been trying to address is that, is there a way we could deal with the challenges of multiple laws, the challenges of there being multiple enforcement authorities in the country, the challenges of having to comply by, or rather comply by seeking multiple licenses, multiple registrations, and returns. So I guess in line with this context, I think the attempt has been made by the incumbent government to kind of simplify the 44 central legislations into 4 labor codes. And in order to do that, 41 of those current legislations have been subsumed under the 4 codes of Code of Wages Bill, which has been approved by the both the houses, and is now a legislation as of 2019. The Code of Occupational Health, Safety and Working Conditions, and the 2 more, which is the Code on Social Security. The Code on Social Security, of course, is quite topical at this point of time, but it's not in the scope of today's discussion. Should be the one that we follow up this series on. And the Code on Industrial Relations. So all the 41 of the legislations are now being broken up and have been actually summarized and simplified and rationalized into these 4 codes. The legislations which are not being merged and are not part of any of these 4 codes are PF Act and the PF Scheme, the SIC Act and the SIC Scheme, the POSH Act of 2013, and all the other professional tax acts. Okay, so moving on, I think if we were to just focus on the 4 labor codes, I mean, this is a little bit generic across the 4 codes, and then we will move to the stuff which is specific to the wage code. I think from an employer perspective, the advantages that we're looking at is the definite reduction in the cost of compliances. The very fact that 41 labor laws are being subsumed across 4 in itself means that there will be a lighter touch in terms of compliance, and that lighter touch essentially shows up in terms of cost savings. It also means that a lot of current processes and activities which need us to kind of move around different offices to kind of resolve disputes, I think all of that can be done centrally and of course through a digital environment, which also will lead to eliminations of significant high cost of claims towards beneficiaries. Incidentally, 2 interesting inclusions that we are seeing in the codes, that post the amendment on the Maternity Benefit Act and the kind of reactions and public outcry and feedback that came in for some of these, some of the changes suggested, especially in terms of increasing the time period of the benefit of maternity benefit. I guess the government has decided or has come out and have suggested that they will actually bear part of the maternity benefit cost. It's not perfect yet in entirety. There is scope for improvement, but that's an inclusion. Also, gratuity cost, also the government is likely to bear, but as I read the code, it's specifically for the Section 4 category of workers, and part of the cost, to some extent, would be borne by the government. Of course, we need to see the details of it and read through it to know exactly to what extent. I think one of the recommendations that I read was about 2% of the wages, but I guess we need to see the details. Also, the provisions of there being 1 license, 1 registration, I think it's interesting and definitely will lead to lowering cost of compliances. Of course, it will also improve the current challenges around the complexity that one has, that ensues in the current regime of multiple licenses and multiple registrations. Sometimes a lot of aversion to compliances happens on account of these complexities, and we believe that one of the upsides of this would be that there would be growing improvement in compliance, and more organizations are likely to comply because the laws having been simplified. And also I think the saving that one should expect in terms of the time that goes in compliances, the number of resources that gets deployed, and the efforts that organizations have to put in to kind of stay compliant. A significant improvement or a significant change is the single authority for implementation. And I guess one of the earlier challenges was the multiplicity of authorities, and that has been to a large extent addressed. A lot of the labor inspections that in the traditional form used to happen in physical form will move to web-based mechanisms and tracking. Also, I think inspectors and facilitators, they are going to give sufficient time to the employers to kind of make the necessary changes to comply with the new codes. And I think that's understandable. One of the questions that we've already got in this is many people have reached out to us asking that while this code is in play right now and is a legitimate legislation, is a legislation, since from when will this be effective? I think we are waiting for the notification, which has still not come, and I think it will actually come in effect post the notifications are shared with all employers. Another change or another, I guess, improvement has been that essentially, while for any offense up to a period of 5 years, any penalties would be in the form of cash or in the form of, fines to the tune. I think if first fine could be to the tune of 50,000 and thereon, but I guess there would be a time period of 5 years that an organizations can have before they repeat the second time the same offense. So I guess there is a window, and if that the person actually the imprisonment clause kicks in only after 5 years technically, so which means that organizations are being given sufficient time to kind of make do any mistakes or any offenses that they might commit. From an employee perspective, I think one interesting inclusion is that the Section 4 category of workers, they need not contribute to the Social Security Fund. This particular amount shall be borne by the government. And I think there has been a mention of the codes being applicable across the entire unorganized and informal sector does raise questions in my mind that how this will be made possible, whether it's implementable or not, given that there has been perennial question mark and criticism on whether the government does have the bandwidth or the wherewithals, capabilities of supervising the plethora of laws that we have. But we'll have to wait and see on what exactly would be the government's plan in implementation of this bit. I think also there is, and I think this is definitely a very welcome move. The first time statutory provision to issue appointment letters to every employee to kind of prevent exploitation and implementation of clear and transparent ways of employee engagement. I think this is a basic entitlement, I feel, for any employee in any form, and it's good that there is a clear mention of this. While it's been a best practice in many organizations and in the formal sector, but I guess calling it out as an important element is key and is definitely welcome. Another key inclusion which we noticed is that the salary disbursement date has been preponed and is now 7th of the subsequent one. So that's the latest by which wages need to be disbursed. Now moving on to specifically the wage code bill, just to give you a snapshot, what it subsumes in one code essentially is the Payment of Wages Act of 1936, the Minimum Wages Act of 1948, the Payment of Bonus Act of 1965, and the Equal Remuneration Act of 1976. So just to share with you some of the new provisions that have been brought in, I think minimum wages and payment of wages is now applicable across organized and unorganized sector. Like I mentioned in the earlier point, that it's interesting, but we need to understand how this will become implemented and how does one keep track of it. It empowers the central government to set different national minimum wages for different parts of the country. Definitely a controversial one. From our perspective, the questions that does rise in my mind, whether India is ready for something like this, and what could be the possible impact of this empowerment. Timely payment to employees without any wage ceiling. As for the last amendment on this front, I think the wage ceiling it was applicable up to 24,000, right? And I think that's been removed now completely, which means this is now applicable to any and every employee without any wage ceiling. Payment of salaries and wages on or before the 7th of the following month, which is about certain 3 days approximately preponement that has happened in terms as against the earlier legislation. Also, eradication of gender discrimination, not just in wages, which used to be at the heart of the Equal Remuneration Act of 1976, but also in recruitments and transfers. A very important move, very welcome move, but again, I guess this has been a challenging area, not just in India, but globally, so we would like to see how this impacts us. Again, the imprisonment clause, which I spoke about, I guess for any first offense, there is no while there is going to be cash penalties, there will be no imprisonment up to 5 years, but yes, subsequent to that, for the second offense, imprisonment could be a possibility, is a possibility. Minimum wages fixed by the state government at no point can be lower than the national minimum wage for that national minimum wage. And I think that's where I feel there is a little bit of debate that's possible on this particular point, but I'm going to get into that a little later. Inspection via randomized selection process, and there's I guess because of the opportunities that exist on account of the digital adoption that's happening across different government departments, there are no geographic limits. The jurisdiction of inspectors have been significantly widened, and web-based electronic labor inspections is going to be a norm. Deposits of undisbursed dues with the government in case of death of an employee where there is no nomination. Also, the inclusion of digital mode and check mode as legitimate mode of payment of wages is an interesting one. It's been always a contentious one whether one can use online transfers or other digital modes, and it's been called out specifically, and that's good. And I think it's in line with the digital wave that's happening. It's in line with the alternative payment modes which are being widely used and becoming popular across the length and breadth of the country. And of course, contract labor to be treated on par with regular employees. Interestingly, there was no such provision which allowed this discrimination, but I think it's been for good measure and for based on certain realities that exist at different workplaces. I think that's been amply reiterated and clarified. So some of the advantages we'd like to call out from an employer's perspective. I think the code applies to all sectors of employment. It's actually talking about applicability of minimum wages for all, including the unorganized sector. I think it brings in clarity. The definition of employee includes employee in the supervisory. I think this is an important one for employers to understand. So I think one of the challenges of our labor laws have been the multiplicity of definitions across various acts. At one point, till recently, there has been at least 21 definitions of workers and maybe more than 17 definitions of wages. But I guess the importance of having this definition become all inclusive, it has important consequences in terms of everybody being on the same page and be clear about what's the definition of employee. Disparity in wages applicable in different states has been reduced. While again, from an execution perspective of employers, it makes things possibly easier. But again, I mean, I personally have questions on how how this would be made possible, because this is not a number which can be randomly generated, but it is definitely dependent on the economic prosperity, cost of living of a particular region in a state. So while it does simplify things, but I'm actually worried about how this will be a true reflection of the wage of a particular state. No salary ceiling, like currently it's, as I mentioned, was 24,000, but at this point of time there is honestly no such limit, so it applies to everyone. Demand could be, I mean, I think one of the outcomes, given that there are now clear guidelines and provisions about how intermigrant workers have to be treated and the kind of benefits and need to be offered, or compensation that need to be offered to enable any such migrations from different state, different places to another. I guess it's likely to encourage employers to source locally. I'm assuming that's one of the intended consequences or benefits of bringing about these changes. Grievances can be addressed for all categories of employees within the framework of the labor codes, ensuring uniformity in treatment, avoiding disputes and litigation cost. Again, uniformity is a big thing. I guess earlier different acts with different jurisdictions had different definitions. And I guess that led to a lot of challenges, a lot of disputes, and I guess a lot of simplifications across the acts that are subsumed around the wages will, I think we would be able to handle that better here on. Inspections will be done on the basis of the inspection scheme, which will include a web-based inspection scheme. Again, I feel that these are definite benefits, and I think given the proliferations and use of internet and access to bandwidth, it's a welcome move. Some of the challenges, I think the definitions of wages does not include house rent allowance, which is definitely which is not really in itself a challenge, but 50% of the allowances paid shall be part of the basic wage for computation. That could be possibly challenging for some employers. A claim for payment of minimum wage could be made within 3 years, as against the prevailing provisions that claim can only be made within 6 months. This can be a problematic one. A higher amount of penalties for contraventions. While it's challenging for some employers, I guess there is no way out, because this is probably one of the ways that one can ensure better compliance of the laws. Courts can take cognizance of an offence punishable under this code if a complaint is filed by an employee or a registered trade union. Yeah, this is definitely something that we need to look into, and I think various representations that have been made on this, and there a representation that we ourselves have gone back to the ministry with, is to clarify this bit, because this could become a potential challenge for employers. I think the big question mark here is on the wage code bill is going to be whether on the empowerment of central government to set national minimum wages across different states, and the fact that the state government cannot set a wage which is lower than that. I think this definitely is a contentious one, because I think there was in recent past there were some suggestions based on not much factual evidence, suggestions or certain numbers were floating around at what could be the national minimum wage, and that definitely created a lot of furor across the employer community, because there is a difference in cost of living, let's say in a state of Orissa as against the state of Delhi. And I think everyone's question would be the mechanism that could be adopted by the central government in terms of determining the minimum wages. So this can be potentially a tricky one, given the disparity, given the gaps in economic prosperity across every state, and this needs to be dealt with a lot of caution and maturity on the part of the government. Otherwise, um, this can have a lot of impact on on job creations across in certain state as against others. I think we are pretty much at the end of. I intentionally did not want to take you through the what? How many pages are this the code, which is almost probably 29 pages. And I'm sure all of you can download it at any point of time. If you want to take a copy of the excerpt, do visit us at teamleasecompliance.com. I mean, just to take a minute to tell you about teamlease.com, it's the only repository in the country which will tell you about every possible law and every update out there. It's not restricted, by the way, to labor laws. It's across any compliance, the 7 buckets of compliances that any organization need to undertake. It's absolutely free, so do subscribe to it. You can also download Rulesbook, the mobile app, and based on your industry, based on the number of locations that you operate, it will be a customized reckoner in front of you of the kind of compliances that you need to do, not just on labor laws, on commercial aspects, on taxes, direct or indirects, on board governance, and so on and so forth. So it's all available to you. Please do download it. And I guess we're almost towards the end of our sessions, but I'm going to actually take another 10 minutes or so to take some of your questions. So if you have any questions for me, please do post and we'll try and address. You can shift to. True that the date of implementation, can you change that? Can this the Yes, it's true that while it's been passed by the parliament, we do not have any notifications, especially around the rules yet. I guess we just have to wait for that, and I think, but it's important for us to be prepared with the nuances till such time. But yes, there is no such notification yet.
The next question is there a
Is there timelines for FNF2? I think we have to wait for the rules to kind of get answers to some of the specific questions on this front. But as soon as we get to know and the notifications comes out, we will definitely post you the responses to that. Sorry, wait. Let me just go through the questions. What is the salary ceiling? At this point of time, the provisions of the Payment of Wages Act was applicable up to a wage ceiling of 24,000. Wage ceiling, salary ceiling being interchangeably be used. That limit has now been removed, which means now it's applicable to any employee at any wage level. Explanation on the definition of workers. If I were to reflect on the definition that have been specifically on the wage code, employee means any person other than an apprentice engaged under the Apprenticeship Act of 1961, employed on wages by an establishment to do any skilled, semi-skilled, or unskilled manual, operational, supervisory, managerial, administrative, technical, or clerical work for hire or reward, whether the terms of employment be express or implied, and also includes a person declared to be an employee by the appropriate government but does not include any member of the armed forces of the union. So that's the definition of an employee as per the wage code. Let's see. Impact of what on international workers? I think there has been some impact on the Social Security Code on international workers, but that we will definitely cover in our next Labor Code series on 14th of October. Yeah, in that there are some impacts for international workers. You have to stop moving that. Give me this here. I'll take a look. Oh, cool. I think there are some questions on PF and how PF is being calculated. My view is that given the new provisions of what's been mentioned by the Supreme Court as well as what's there in the wages code, creativity in salary structuring to avoid social security or to lower the burden of social security is minimal at this point of time. Can I just go to the beginning? Is this the beginning? Going up is the beginning? Okay. Has been passed. No, any variable pay which is linked to performance or is in the form of incentives is not in the gambit of any wage definition. The minimum wage at this point of time is notified by every state and is published in the respective websites on labor of each state. And if you want more details on this, again, feel free to reach out to us. We will be able to help you, but it's all available online at this point of time. Could you explain the wage definition? I would err on the side of reading it out and wage definition. Okay, the definition of wage. Okay. I'm just going to quote as it appears in the code. Wages mean all remuneration, whether by way of salaries, allowances, or otherwise, expressed in terms of money or capable of being so expressed, which would, if the terms of employment expressed or implied were fulfilled, be payable to a person employed in respect of his employment or work done in such employment, and includes basic pay, dearness allowance, and retaining allowance, if any, but does not include any bonus payable under any law for the time being in force, which does not form part of the remuneration payable under the terms of employment, the value of any house accommodation, or of the supply of light, water, medical attendance, or other amenity or of any service excluded from the computation of wages by a general or special order of the appropriate government. C. Any contribution paid by the employer to any pension or provident fund and the interest which may be accrued thereon. Any conveyance allowance or the value of any traveling concession, any sum paid to the employed person to defray special expenses entailed on him by nature of his employment, house rent allowance, remuneration payable under any award or settlement between the parties or order of a court or tribunal, any overtime allowance, any commission payable to the employee. This essentially is the response also to the variable pay question that I was asked a while back. Any gratuity payable on the termination of employment, any retrenchment compensation or other retirement benefit payable to the employee, or any ex gratia payment made to him on termination of employment. Yeah, I think just go through page number 4 of the code, and it's quite well established there. Please, are there any more coming in? If the state wages are higher than the central wage, ideally the state wages, always. The notification will be required for the rules, yes. For it to become effective, yes. We do need to see the rules and it will be effective. And also, as mentioned, the government is ready to give adequate time for employers to make the necessary changes based on the new legislation. Are there any further questions?
There are.
Oh, there are. Wow, quite a few. The entire, the entire session will be available online, so you can refer to it at any point of time. I just shared with you the definition of wage. Hope that answers your questions on that. Is there a government site? There is no government site, but that's why I probably would urge you to subscribe to TeamLeaseCompliance.com, which essentially has built an extremely state-of-the-art mechanism to kind of scroll through 2,000 government websites daily, and almost on an hourly basis, updates are being made visible to you through TeamLeaseCompliances.com on any such changes, including minimum wage changes that are happening across every state. What we also try and do is give you a compressed, easy to understand version of any of those updates, along with an excerpt, along with the downloadable version of the entire update or notification or gazette. What is the impact on employers addressed? Okay, there's a question on how it will apply to trainees. By anyone besides an apprentice, it comes under the purview of these acts. So the apprentice, by definition, is the only one who stands outside the purview of this code. I think there are some very interesting questions, like the question on any change in respect of ceiling of wages in terms of Payment of Wages Act in case of death of an employee. I would urge you to write in a little more in detail in terms of exact, context behind these questions, and I'm sure we can respond to you on that. So PF and ESIC, at this point of time, there is no clarity whether PF and ESIC will be merged with Social Security Code, or Social Security Code will emerge as a distinct fund or a distinct scheme over and above that. So we are waiting to have clarity on that. At this point of time, there is no clarity on that. I think there is a question on death of an employee multiple times. I think we will try and address that. So you can respond to that. There is no mention of change in the statutory bonus payout so far, right? It remains the same. I think that is the retrenchment decisions are not in the scope of this particular code, but that should get covered in the industrial relations one. I do not have a view on whether the paying currently we pay for the rest of life basis 50% of 8,000. I honestly do not have a view of how it's likely to be into the future, and there is no such again, I am not an expert, but as far as my knowledge supports me at this point of time, there is no definition of 50%. Pardon? Yeah, it will be under Social Security, but even that 50%, there is no such legislation which prescribes it as well to be 50%. Now, there are no mentions on golden handshake that I have seen in the wage code. There would be, again, this is something which somewhere aligns with the industrial relations one, so we'll have to wait and see if that gets covered there. Again, I want to remind you all that this encompasses, besides apprentices, this encompasses everyone. And if there is any definition of a form of individual at workplace which is who is not an employee based on a gazette notification, I would like to believe it excludes that, but I would let the experts come back to you on that. PF has, yes, it's applicable in Jammu and Kashmir now. PF is applicable in Jammu and Kashmir now. There is no norm on to what extent contractual employees can be extended. However, the occupational safety and health has a significant mention on contractual staff, so we'll cover that in the next one of the future code discussions. Which is a WC Act? What is WC?
Workman compensation.
So which one is it covered?
That,
So the workman compensation is covered under the Social Security Act. Any more questions? Okay, just wanted to share with you all that We will, all those of you who have registered, we will get back to you individually, one-on-one, share with you an email which kind of gives you a link to the today's discussion, and we will also try and address some of the questions that you might have raised. We'll also share with you details of the next labor code, and that's on 14th of October. Do save the date and join us in. And I would also urge you that do send in your questions around the occupation. We're doing the occupational safety and health next, is it? We don't want to do social security next?
No, so it's just
What is it? Okay. So we're going to do the occupational safety, health, and working conditions next. So do send in all your questions on this particular code to us well in time, so that we are ready with some of your questions and we might be able to address them during the course of our next webinar. And I would also urge you to kind of download a copy of that. It should be easily available in the teamleasecompliance.com website. Do also download rules book, because this gives you, these are extreme, and these are all free, by the way. There are no costs associated with this. I guess these are ecosystems that should have been made available. Shift it back. These are ecosystems which should have been made available to us in general, but I guess we just seized the opportunity and created something of this nature. The intent also was to draw people's attentions to the extent of complexity. Sometimes it gets lost. There are 58,000 compliances to be done every year. There are in excess of 1,084 acts. There are in excess of 3,000 filings, and so it's an established fact, and it's a factual number out there to kind of establish how difficult it is to comply in this country. So the idea is to use this repository first and foremost to make employers aware of their compliances, their do's and don'ts, and side by side also draw attention of the public policy makers in terms of what needs to change. It's a very logical grouping, should help you. And do keep sending in your questions. And if you have any further questions on the wages code, also do write in. All channels are open. We are very easily accessible through social media. You can write into us at any point of time, and we'll definitely come back to you with responses. I mean, the ones for which we have, the others, I guess the responses are with the government. Good. Thank you so very much for spending your time, and we intend to keep this series going. I think the 4 labor codes, after we do the 4 labor codes, we will come up with special sessions and webinars on the challenges that are being faced on PF, possible challenges on UN tagging with Aadhaar, and so on and so forth. So we'll keep this dial tone going for you, so that you're always kept well informed about the changes in the regulatory environment. Thank you so very much for your time, and let's keep in touch.